All right.
Good morning, everyone. My name is Kim Isaza. I am the director of the Cobb Law Library. We had such a great response to this program that we moved down here. The law library is actually 2 doors down the hall. And I encourage you to stop and see it when we're done if you would like. Thank you for coming. Our presenter is Derek Rouse, who is the founding partner of the law firm. And graciously volunteered to do this program on small claims court. There will be time for questions at the end. We are recording it to put on the county YouTube channel for later. And if you submitted a question with your registration, it has been given to him, so hopefully the program will already answer that. But there will be more time for questions afterward. And if you need to use the restrooms, they are out in the hall, the ladies' room. You have to walk past the elevators, almost to the glass, and then it's around the corner, because of course. So, okay, I'll turn it over to Mr. Rouse. Thank you so much for being here.
Thank you, thank you. Good morning, everybody. How are you today?
Good morning.
Okay, great. I don't know, first of all, what the rules are. Can I leave this on? Do I have to take it up? Can I take it up?
You can take it off
Okay.
if you're speaking.
Is everybody okay with me taking this up? Because it is very difficult to talk and breathe at the same time. And just so you know, I always ask judges if I can do that too, so feel special. So as Kim said, my name is Derek Rouse. I'm an attorney. I've been practicing for nearly 15 years. In October, it'll be 15 years. I work in Stone Mountain primarily, but as I said earlier, there's some people in here. I'm like Paladin, if you know, have gun, will travel. I have a car, and I will travel. So I go from Bartow County, Habersham County, Chatham County, Bibb County, anywhere in the metro area as well. I love what I do, and I love helping people. So when Kim and I talked about doing this, it was like, wow, I'm super excited, because this gives me an opportunity to educate people and about this whole process we call small claims court. So let's just get right into it. The basics of lawsuits and things of that nature. First and foremost, like they told us in law school, anybody can be sued for anything. So it doesn't necessarily mean that your case is a viable case. It just means that you have the ability to create a document, file it in some form of court, and have it served on somebody else. That's all that is. That's that process of filing a lawsuit. Individuals can be sued, businesses can be sued, and believe it or not, estates can be sued, meaning a dead person who has done something wrong. Somebody can actually sue that estate in probate court or state superior court, things of that nature. What Georgia does, Georgia has different courts. You have superior court, state court, probate, and magistrate court. State and superior court, that's big boy court. That's where you put, like some lawyers would say, 12 in the box and you try a case. That's and there is no real jurisdictional limit within those courts. Probate court, that's where you would go to handle estates. That's where you would make sure that somebody who had passed, whether they had a will or not, their affairs are taken care of, or if you're seeking to have yourself or someone appointed a conservator of someone who can't take care of themselves. That's probate. I believe Kim alluded earlier that there is a very good program that was done on probate through Cobb County. You can see that on the YouTube channel for the county. I saw it, it really is good. But what we're talking about is the fourth one, magistrate court, AKA small claims court, or as I like to call it, the people's court. And literally, if you watch Judge Judy, Judge Mathis, insert judge show here, or the people's court, that's what we're really talking about. And as an aside, that's actually my favorite show. Not for nothing. So what types of cases are pretty much heard in magistrate court? Okay, we covered that. Let's talk about types of cases. Breach of contract. You can do that one. Having someone removed from a rental property, that's the dispossessory action. I purposefully bypassed the personal injury and other torts because that's something most people don't think about, right? When you go home at night or go home during the day between the hours of what? 8, 9 a.m. to about 7 p.m., you're inundated with lawyer ads talking about personal injury cases. Normally, those types of cases are handled in state and superior court because what we're talking about is money, right? Big time money. At least that's what the commercials tell you. But with small claims court, you can actually try those cases there as well. And I'll tell you how you can do it in a second. Now, some of the cases that are not handled, and we kind of touched on it a little bit. Probate, can't do that. Protective orders, where you're seeking you're seeking to have someone removed from your life because they're threatening you, things of that nature. You don't handle that in magistrate court. Injunctions, trying to get a court to order someone or something not to do something. That's not handled in magistrate court. Family matters, no divorces, no child custody, no legitimation, that's not handled. So those are some of the things that are not handled. But what we're talking about primarily in magistrate court is money. That's what you're trying to get. Either you're trying to get money or you're trying to get property. That's what you're trying to get. Now, important differences, we touched on it a little bit, but let's go in a little bit more detail. The jurisdictional limit in small claims court or magistrate court is $15,000. So in the example that I made earlier talking about personal injury cases, as long as the claim is not going above $15,000, that case can be heard in magistrate court. You're not going to have a jury. It's going to be the plaintiff, the defendant, and the judge. The judge is going to be the one that decides the outcome of the case. And lastly, attorneys are not required. In point of fact, though, attorneys really aren't required for a lot of stuff for either state or superior court, but they're really not required for magistrate court. That's why it is the people's court. The concept is to allow people to resolve their disputes themselves in front of a judge who's supposed to be neutral, and you just bring your evidence and the judge will decide. No lawyer needed. Sometimes, I don't know if you know this, lawyers can complicate stuff. I don't know if you know this or not. And then they have the nerve to charge you. So, okay. Lawyers, man, tell you what.
Are lawyers allowed, like if you take a case and can they bring a lawyer, the person?
That is a great question. Yes. And I had a case a while back where I represented somebody and the other side didn't have an attorney, and it never ceases to amaze me. It's always funny. It's not funny for the litigants, but it's funny for the lawyers. I mean, lawyers said it's not. They don't laugh at this. You're fooling yourself. When the other side brings an attorney, everybody wants a continuance. Very few people want to move forward when the other person brought an attorney. And I can understand that because we speak a different language and you want someone there that can help you speak the language and we're going to get into this a little bit in more detail too, but this whole legal thing, it's its own language. And, but yes, you can bring an attorney. That does typically happen. And then, like I said, sometimes the judge will give you a continuance to allow the other side to get an attorney. And then sometimes the judge is like, no, we're just going to go forward. And then some litigants are smart enough or bold enough, depending on where you sit on the fact pattern, to actually go forward anyway. Having an attorney doesn't make it any better necessarily. It just means someone paid a little more money, essentially. Because I know a lot of people that didn't have attorneys in one cases. So it's fact driven. Let's see, so. But yeah, any questions on that so far? Okay, so these are just the basics. You know, no juries, bench trial, no attorneys required, but you can have them, and jurisdictional limit is $15,000. Let's talk about that real quick. Yes, sir.
How come sometimes the defendants also get the court appointed people to assist them and not the plaintiff?
In other words, there's an attorney there, and sometimes they'll give them an attorney. It depends on what kind of case we're talking about. Every jurisdiction does things a little differently. That's the other issue too. And we'll probably touch on that at some point as well. But in my experience, for a small claims matter, like ABC company is suing XYZ because XYZ did not bring forth 100 widgets and ABC paid $10,000, unless there is typically those cases are handled just between them unless someone else hires an attorney. I haven't seen it where there is two individuals and one has an attorney and one is appointed an attorney at that time, unless we're talking about family stuff. That's where I've seen it. I haven't seen it like this in this capacity. I hope that answered your question. So the short answer is it just depends. As far as the jurisdictional limit, the $15,000, it cannot be $15,001. If it is $15,001, it is going to be transferred to either state or superior court. That's how strict a rule that is. And if we're talking about trying to recapture property, like let's say you're asking the judge to get you your stereo back, it cannot be over $15,000 either. That's how strict that is. Yes, ma'am.
Second relief. Removal from a leased property. Is it the property value, or is it the rental or the lease?
It's the rental. It's the rent. Where you are, that is literally just, that has nothing to do with dollar amount.
The building itself is not the issue. It is how much they owe or you owe that landlord.
If you're doing a dispossessory because of rent and they haven't paid rent, it's still going to fall under here because you're the magistrate court.
What I wanted to make real clear is it's not the abode.
Right, right.
Not the value of the abode.
Right, it's not the value of the abode. We're talking like property like computer, car, because car, it can't, like I said, it can't be over 15,000. So it's a small car or an old car. Yeah, so that's a good question. Let's see. Now, let's talk about how the process works a little bit. First and foremost, you as the plaintiff have to have one thing that's very critical. No, it's not money. No, it's not an attorney. You have to have a wrong. Someone had to have done something to you, meaning you entered into a contract and the other side didn't abide by the contract. Someone physically harmed you. A really good example, dog bite cases. You know, someone got bit and they have $5,000 in medical bills and they want to be reimbursed for that. Those types of examples, those types of things. So you have to have a wrong. Once you've had the wrong, now we need to talk about knowing where the defendant is. Meaning, if the defendant lives in Fulton County, but you were hurt in Cobb County, you're not suing in Cobb. You're suing in Fulton because that's where the defendant lives. Now, if the defendant lived in Fulton County and the wrong happened, or I'm sorry, let's scratch that. The defendant lived in Cobb County, you lived in Fulton County, you're the plaintiff, you sue in Cobb. The point of that is you sue where the defendant lives, not where the wrong occurred. And a lot of people don't know that. It's totally based on where the defendant lives. Now, once you figured out, well, let me go back a bit. Let's say the defendant is a corporation, right? You have to sue where the corporation is. Same principle. Everything is either, whether it's an individual, whether it's a corporation, partnership, you sue where the defendant lives. Now, where you serve them, that's where you would go look at the Secretary of State's website to see where they're registered, and that's where you would actually serve the complaint. Yes, I'm gonna start with her and then come back to you. Yes, ma'am.
I was gonna say, if they have incorporated, let's say it's 3M. 3M is also located on, let's say, Peachtree Industrial. However, they're in St. Paul, Minnesota. Their main corporation headquarters is in St. Paul, Minnesota.
If they're a registered, they'll have a registered agent here in Georgia. So what you would do is you would serve that registered agent.
DeKalb.
Right. And then that's where you would go forward with that. Yes, sir.
So essentially, along that same line, in the case of a company like Home Depot, which is located right there in the corporate office in Smyrna, but obviously retail locations all around the metro area, you serve at the corporate location?
You would serve the corporate headquarters because that's where the registered agent would probably be, but you would probably still be able to sue at, let's say, Home Depot and DeKalb. That's where it would be heard.
Okay.
So you're not necessarily having the hearing and the whole process of preparing for the trial, things of that nature, in that county where the corporate headquarters is. It could, as long as they are properly served. The issue is the service process.
So would you do a dual service?
Depends.
Headquarters plus the defendant?
You could.
Let's say DeKalb County.
Right.
Wherever that Home Depot is.
You could. But see, and that brings me to my next point. There's some forms up here, I don't know if everybody got them, but and you're jumping the gun a little bit on me, which is fine. No, it's fine, I love it. So as with anything, when you go through this process, you have to come out of the pocket, meaning you're paying, there's certain things that you're paying for. But let's before I get to that point, the next point that the plaintiff has to do is complete a statement or complete a claim form. That's what this is. I don't know if anybody has one, or if you need some, we can get it to you. But this is a statement of claim, and what it does is it lists the plaintiff's name, their address, phone number, defendant's name, address, phone number. You do not need to fill out this part that says civil action. They'll do that. The clerk staff will do that. And then the most important thing is where it says statement of claim, and that's where the plaintiff just writes out what they believe happened to them and why they feel this person did it and what they're seeking in terms of damages. Now, I think one of the questions asked, do you need to prepare it the way an attorney would? The answer is no. Just write out what happened the best you can and put what your damages are. And do not be afraid to use more than one sheet of paper if it's necessary. You can always, because that's not enough to do anything. So I have seen it done in the past where people, write a little bit here and then finish on another sheet of paper. You can do that. Yes, sir. You had a question.
Yes, in that statement of claim, I've seen it where you've written out your claim as the people's court. However, the defendant, if they hire an attorney, might come back and say their statement of claim doesn't apply to legal code or whatnot.
Right. Right.
From that point, as the people's court, how am I supposed to know legally what code to cite? And
hold that thought.
all right.
Hold that thought. We'll get to it.
All right.
Yes, ma'am.
No, I'm just.
Okay. I got to look for you.
That's the ADD part.
Okay. Yes, sir.
If somebody I was involved in a traffic accident,
Mm-hmm.
and the other party, in my opinion, was at fault.
Mm-hmm.
and nobody's disputing what happened, but on her driver's license is what I had a copy of, and that's where I had her served, and she didn't live there anymore.
Mm-hmm.
Is that a big deal, and should I bring that up?
Are you in litigation now?
Not yet.
Not
Well,
yet.
I mean, we've got a hearing coming up.
You have a hearing coming up. Was she served? She wasn't served.
No, I had to go pay another $50 when I found out where she was living from the insurance company.
Okay. Is she still in the county's jurisdiction?
Yes.
Don't bring it up. You don't necessarily have to bring it up. The issue is,
Well, I
does
didn't
the court still have jurisdiction over the person? And as long as she's still within the county, even though she moved from point A to point B, but is still under the county's control, you're still good.
Well, what I meant was, is there any penalty to her for not having a proper address on her driver's license?
Do you know?
I don't care if they penalize her, but I'm talking about, is there any advantage to me to bring that up, other than the extra $50 I had to pay?
No. No.
Okay.
It's a short answer. Yes, sir.
Yeah, there is a statement of claim that says suit on a note.
Right.
On the account or other, what is that?
Suit on a note is like, you have you could use it as a breach of contract type of deal, things like that. An account would be your Macy's account, and Macy's coming after you because you didn't pay the bill. And other is tort, dog bite cases, whatever. That's it's kind of done like that. So once you've completed this, then you have to go to this sheet of paper, and I think you know about this. This is the sheriff's entry of service, right? And you do the same thing. You put your name and the defendant's name, address, and where the person is supposed to be served. The sheriff will take this along with this, and go to the person's house that you have listed here, and they will execute a service of process. It's usually in DeKalb County, it's the marshals that do it. DeKalb County marshals will do it. The sheriff's department will do it. But there's a fee for both of those. So let's go back to this young lady's question, whether you need to sue corporate and the entity. If you do, you're paying the filing fee to file the complaint, and you're paying 2 service fees because the sheriff has to serve 2 different entities. So that's something to be mindful of. Yes, sir. It depends on the county. Each county is different. I've seen it $50 for the process fee. And by process fee, I mean having the sheriff go out and actually effect service. So in this hypothetical, it would be $100 on top of probably the $82 to actually file the complaint that you would have to pay. Now, that money can be, I think I may be going where you're headed, maybe. You can't ask for the money back in the complaint. And you can ask for the money back at trial if it gets to that point. Did you have a question?
How do you know if it's a business owner and he has a corporation, but it's his business, and it's just one location? Do you sue the business and the individual? It's a dentist.
When I do it, I do both.
You do? Okay.
I do both.
Okay.
I'm doubling down.
Okay, just in case.
Because you never know. You don't have to do it that way, but you can't, because what the LLC is supposed to do is supposed to protect the person from getting their personal assets taken, money, things of that nature. However, sometimes you may get lucky and you can pierce what's called the corporate veil and get them that way. But so I would do both. It doesn't hurt.
Is it 2 separate lawsuits, or is it 2 people?
1 lawsuit, 2 defendants.
Okay, thank you.
Yes, sir.
There are private processors out there as well who are,
Yes.
county has it, and we use it all the time.
Yes, that's a good point. And I didn't think about that and put it aside. Private processors, very good people. I prefer dealing with them than I do the sheriff. That's just me now. And the reason is because, number one, I can say, Fred, and if they didn't do it right, or if they didn't do it when I needed it done. But typically, you give them the complaint and things of that, and they'll go out and they'll tag them or tell you why they couldn't do it. But the point is, you have more contact with them than you would necessarily the police. I had a case one time. We filed the complaint and said, here, X County Sheriff's Department, go forth and serve, and they darn near messed up with the statute of limitations, and we had to find someone else to do it. And I said I would never do that again, because I need to feel like I'm in control of something. Yes, sir.
If you don't mind, with the sheriff entries of service, could
Yes.
you just quickly just run through those things?
Absolutely. So let's say personal. I have this. This is what when the sheriff goes out to effect service, these are the things that he is going to check off. Where it says personal, I have to take off my glasses to read. I have this day served XYZ personally with a copy of the written action and summons. Now, what's that saying is, yeah, I tagged them or I served them. I gave them the paperwork. Now, understand, it doesn't have to necessarily be that individual defendant. It could be a relative that lives in the house, as long as they're of a certain age. I want to say it's at least 15, 16. They can actually accept that document. And if I'm wrong about the age, I'll look it up and make sure we get it to you so you'll know. Notorious, I have this day served blank by leaving a copy of the action and summons it at his most notorious place of abode in this county. I didn't give him the document personally. I didn't give it to anybody there, but I left it at this house, or I served this person by leaving it at the house. Corporation, you would serve the registered agent for that corporation. Now, in the tack in the mail, typically, let's say if you're trying to evict somebody, because that's what a dispossessory is. You're trying to evict somebody. Typically, what happens is they'll literally tack it to the house, and that's how that person has been served. And then the last one is, we tried, but we couldn't find them. Does that kind of answer you? You good?
It does.
Okay. Yes, sir.
What is the length of time that a person has to file a case?
Depends on what you're filing.
Let's say it's a dispossessory, but they've already left, but they owe you back rent.
So what you're doing at that point is filing probably a breach of contract action, or on a note, on an account, whatever you want to call it. Georgia is, breach of contract statute of limitations is, depending on what it is, I want to say 4 to 6 years.
Okay.
So you have that length of time to do it. Now, if it's an injury, dog bite, car accident, you got run over by somebody on a bicycle, 2 years.
2 years. Okay.
2 years.
That's a tort case, correct?
That's a tort case.
2 years.
2 years.
And what constitutes a tort case, that is not the other two?
It's essentially, torts are essentially personal injury. Anything involving some form of harm that is not a contract, that is not a dispossessory, things like that. A tort, the best definition they describe it, is a wrong. But it's typically a wrong that in this context is going to be a physical, something like that. Bodily thing, kind of sort of deal.
Slip and fall.
Slip and fall, right. Slip and fall. As a matter of fact, you could use a civil claim to, if you wanted to, bolster a criminal claim, and vice versa. If someone, hit you over the head with a bat, you could sue them for damages. Any other questions?
If you lose in small claims court, can you still sue them in a different court?
Hold that thought. Hold that thought. You guys are asking great questions. Okay, let's see. So, all right, so we covered all that. Now, you're the defendant, and the man has come over to your house, or the woman has come over to your house and dropped off these lovely documents. Now, after the anger has subsided, now the rational thought and thinking has to come in. So what is your responsibilities? Well, you did the first one. Reluctantly, you accept the summons and the complaint. But now you have to answer the complaint. And you have 30 days to answer that complaint. 30. Now, if you do not answer the complaint, you are in what's called default. Now, that's not necessarily the end-all be-all, because in Georgia, you have 15 extra days to answer the complaint, so 45. However, with the 15 extra days comes money that you have to pay to the court to allow you to answer that complaint. Now, so eventually you answer the complaint. Now let's talk about the answer. What I did, I diligently looked, okay? Just putting it out there. I diligently looked for a template answer from Cobb County online, so I wouldn't have to go to the courthouse to go get it. Could not find one. So the answer, this is a sample answer that you guys should have. If not, we'll make sure you get it. But what it does is, essentially, I got this one from Fulton, and Kim was kind enough to white out the Fulton part. But you can still use this, because the principle's still the same. So you're answering this complaint, and if you have it with you, you can take a look at it. Again, I have to take my glasses off so I can see. You're just going to check what applies. Either you're going to admit to the claim, you're going to say that you're not indebted to the plaintiff, you're not indebted to the plaintiff in the amount that the plaintiff alleged, things of that nature. And you also have an opportunity to file a counterclaim if you wanted to, meaning, well, the plaintiff is suing me for this, and I feel I have a claim against the plaintiff for that. So I'm going to answer the complaint, but I'm also going to counterclaim or file a countersuit against the plaintiff. And the same rules apply for the defendant. Jurisdictional limit is $15,000. So if you're counterclaiming for $15,000 and 1 cent, that's not going to fly. It's going to get transferred to either state or superior court, because the jurisdictional limit is higher than, or what you're asking for is higher than the jurisdictional limit. So everybody kind of understand that? Yes, sir.
So what's the harm in having it transferred to the state or superior court?
Timing. One of the reasons why I like magistrate court, and it's also the same reason why I don't like magistrate court, is timing. Magistrate court moves quickly. State and superior court, a little slower. Because with state and superior court, you also have to factor in not just the civil stuff, but the criminal stuff. State court, you have misdemeanors. Felonies are in superior court, and especially given the pandemic, the criminal cases are backlogged. Thank you. Very backlogged. So it's taking longer to get the civil cases resolved. I have civil cases right now that date back to 2018.
Wow.
That's how bad this is. With magistrate court, typically, once the answer is filed, and the answer in the counterclaim, if necessary, is filed, you're on the calendar within the next 30 days to actually try it. So that's the biggest advantage to it. And it's also a disadvantage if you're not prepared, and we'll talk about that in a minute too. Yes, sir.
let's say that you're doing a suit for the 15,000, and you also want your legal fees, Is the 15,000 okay, and then the legal fees can be added on top of that, or does your suit have to be like for 12 and the max is 15?
I have to tell you that your jurisdictional limit is $15,000. Yes, sir.
You previously mentioned the sheriff does the process serving, but there are individuals, personal process servers.
Right.
Where do you find them? How much do they cost?
You can find them online. I would Google process servers and see what you come up with. Everybody, you know who's really good? Private investigators. They're really good too. I've used them before. Used one time. He found somebody that the police just could not find. I'm like, I don't want you to know how you did it. I may have to testify. But, you know, so yeah, I would do that. Process servers. Yes, ma'am.
I was just going to interject. There is a list on the Superior Court website of private process servers.
Yeah, every county has it, by the way.
And that's a good point too, because there are some process servers that have already gotten appointed by the court to effectuate service. Start there. If that doesn't work, Google. If that doesn't work, call my office. Is that fair? Okay. Yes, sir. You had a question.
How many times do the sheriff serve
You really want me to answer that? No, I'm playing.
You know, they give it to a 15-year-old, and then they claim they don't get it.
Right. I've had them go out a couple of times. I've had them go out once, but usually 2 times. I don't know how often. I don't know if there's a set limit of times that they have to go. What I know is some of them have gone out for me at least a couple of times. And one time they couldn't get them, they went back out again, they got them. 2-3 times they couldn't get them, and then they'll send you this back, right? And this will be checked off, the last one saying that we tried but we couldn't get them. And you can barely read it because it's on very fine paper, very fine paper. It's like the 3rd page that you do get, and you're like, okay, so now I got to go hire somebody. So, but I don't know. You had another question?
Yeah. What if the defendant was counterclaiming, but you didn't know nothing about it?
Say that again?
Giving you a suit,
Uh-huh.
but you didn't know nothing about it. They was counterclaiming against you?
Oh, really?
Yeah, but you didn't know.
Don't they
You have to be served.
Oh, I see what you're saying. Good point. That's a good point. Typically, you are not going to get served as the plaintiff with the counterclaim. What you will get, what you are supposed to get, is the copy of the answer, and behind that will be the counterclaim. That's how you should know. Now, it's not uncommon, I have seen this too, where a plaintiff comes in totally blindsided that the defendant has filed a counterclaim, and that's the first time that they hear it, okay? And the case is called in for trial. So you could do this. I don't know if it'll work, but you could do it. You could ask for a continuance to give yourself time to get prepared because you didn't know about the counterclaim. You do have that right. You can ask. Or you can take a look at it right then and there and figure out, you know, whether this has legs or not, and if it doesn't, go forward with it. Because I'm trying to think of an example. I had, on a dispossessory case I did a while back, and remember, I don't think you were in the room, and I think there's some other people that came in late. With magistrate court, you do not need to have an attorney present to go forward with the case. Well, so with that said, this young lady hired me to do a dispossessory. We get in there and everything's going well. She's about to get kicked off South Fork, and and all of a sudden we hear that she filed a counterclaim against my client because my client didn't provide something that she was supposed to provide for in the contract, the lease agreement. And that's the first time we hear about that. It didn't have any legs. Judge still ruled in our favor, and we were able to keep moving, and the young lady unfortunately got evicted. But it's a judgment call really on your part. But you are supposed to get a copy of the complaint and the counterclaim. That's how it's supposed to work. Yes, ma'am.
Whose responsibility is it to get that to you?
Well, it should be the clerk's responsibility. Because what typically, especially in this day and age, because when you file your complaint, not only are you giving them your name, your address, you're giving them also your email address. So everything is supposed to be done via email. So the counterclaim, the person doesn't have to necessarily come to the courthouse anymore. You could just counterclaim and answer and counterclaim and upload it. And the system is supposed to just send you a copy of what was filed, because when the clerk accepts it, they put a stamp typically on the right corner, letting you know that this document was received, and the system should generate an email directly to you. That's why it's very important to make sure that you put all of your information in that, so you'll get it.
So that comes through Peach Court?
That'll come through Peach.
Depends on county, but Peach Court is.
Cobb is Peach Court for state and Superior. I want to say it will for magistrate, but I'm going to tell you now, double check with magistrate court clerk's office, because they may be doing something different. Either way, you should be able to get that information online or through an email. Okay.
In Cobb County, we are not getting an email.
You're not getting an email from magistrate court?
Yeah.
Huh.
Yeah, it shows up in a, snail mail after,
Now,
and a court date maybe next day.
right. Now, and typically, like I said, my experience is it goes through online and I get an email notification, but that doesn't surprise me either.
Mm-hmm. Yeah.
That doesn't surprise me either.
No place to fill out your email address to begin with on the form. Unless you
Okay.
file it online and do it.
Yes, sir.
Can you sue the post office? I'm very serious. When
I know you are. I know you are.
And the reason I'm saying that is I've seen the truck hit my mailbox, as well as the doors damaged, and half the time I don't get my mail. Can you sue them, at least for the mailbox value?
That's above my pay grade.
Generally, you go to the post office that is assigned to your zip code. They have the top person, the postmaster general, at that location. That's where you start.
I would say you got a problem, since the mailbox belongs to the post office. Not to
Then why
you.
did I have to pay for it?
Right.
It is
Okay.
as it is. It's in the right of way.
Okay, I'm sorry. You guys are asking really good questions, and I have 14 minutes, so I'm going to try to move this along a little bit quicker. Kim is going to make sure you get a copy of the PowerPoint presentation. My contact information is there. Please call me if you have any questions, okay? Don't worry about the bill. There's not going to be a bill. If you have a question, just call. I'm not that kind of lawyer. I want to help educate. So,
Thank you.
you're welcome. So let's talk about trial prep real quick. You get a court date. The court date is, what month is this? July. Let's say August 21st. Day before my wife's birthday. So you have to go to court on that date. Now, what do you need to do? Both sides. Number one, if you have witnesses, call your witnesses way ahead of time. Make sure they can get the day off. And if they need a subpoena, make sure they tell you that ahead of time. That way you can come down to the clerk's office to get a witness subpoena. Documents, if you need documents, let's say it is a dog bite case, and let's say you need the medical records. Let me tell you something. You want certified medical records. Why? Because you don't want the doctor, the billing manager, whomever to come in and give testimony. They be expensive people. You don't want that. You get the medical record certified. It's a self-authenticating document. It speaks for itself. You can get that evidence in that way.
How would you get them certified medical records?
You call the billing department at the hospital. Thank you. I couldn't think of the place where it is. And you tell them you're trying to get these medical records and you need them certified. Use those magic words. They should be able to give it to you. If you run into any problems, again, PowerPoint presentation has my contact information. Give me a call. So once you have all of that and you're getting ready to come to court. Now, let's go back to the witnesses real quick. Not only you have to make sure your witnesses are available, you have to make sure the witnesses are going to testify the way you need them to. I'm not telling you to tell them to lie. What I'm telling you is make sure their story is on point and straight with what your facts are. Because there is no more terrifying and frustrating experience than going into court thinking that your witness is going to say A and they end up saying Z. And Z does not help you. That has happened to me, trust me. All right, so we talked about that. Let's run through this quick. Now, any questions on that? Does anybody have any questions on that? So let's get to the trial part. First and foremost, show up for trial. Yes, sir.
I'm sorry, the witness subpoena. Now, I saw somewhere in the court thing, do you have to pay for that?
Yes.
Okay.
Yes.
All right.
Yes.
You pay ahead of time?
You pay when you pick up the documents. When you get what they'll do is you go to the clerk's office and you say, I need 5 witness subpoenas. And they'll give you the witness subpoenas, they'll stamp it, and they'll give it to you, and then they'll give you the bill. Okay. And then you pay it at that time.
Okay.
So, trial process. Show up for trial. Can't stress that enough. If you don't show up for trial and you're the plaintiff, the judge can kick the case. If you don't show up for trial and you're the defendant, the judge will rule in favor of the plaintiff. Show up for trial. Now, judges are very busy. Has anyone been to a magistrate court hearing? Okay. Wasn't it crowded?
Yeah.
Wasn't it fun? No, it wasn't fun. So what the judge, because it's crowded, because it's the people's court on steroids, they will try to get you to mediate. Meaning they'll ask you to step outside, the parties will step outside and they'll go talk to this nice person who is the mediator. And the mediator's job is to try to reach some settlement with you guys. Please take it seriously, okay? I cannot tell you the number of times I have gone to trial, especially in magistrate court, where neither side took it seriously. And you're just talking to this nice person who is just the unfortunate soul who was selected to deal with us for 2 minutes. Enough to say, hello, my name is this is what the case is about from our perspective, and the other side will do the same. And then sometimes they'll put you in different rooms and the mediator will go back and forth to try to get it resolved. And typically, if you can come to an agreement, do so. If not, then you'll go back before the judge, okay? And when you go back before the judge, that's when you have a full-fledged hearing, okay? Sometimes the judge will allow the parties to do what's called an opening statement. In magistrate court, I don't do that. I just get into it, and you have that right if you want to. And the opening statement just gives the judge the idea of what the case is about from the plaintiff's side and what the case is about from the defendant's side, okay? Once that is done and the plaintiff begins to present their case, witnesses can come up and testify, or they'll present evidence in the forms of documentation, things of that nature. Once that's done, the defendant has the right to cross-examine the witnesses and challenge the evidence that's been put forth. Now, and vice versa, defendant can do the same thing, present its case, witnesses, things of that nature, and plaintiff has the right to cross-examine also. It is very important to understand this, and this is the part where it can be considered unfair. Last I checked, if I'm wrong, I apologize. There's only one person in this room that has gone to law school, right? Just me, right? However, when you go through this process, the rules of evidence are still in play. Meaning, if this young man and I had a conversation about something and I'm suing this young man here and he knows about it, and she said something to him about our dispute, and I call him as a witness, but I don't call her, if he testifies to anything she said, that's considered
Hearsay.
exactly, and it's inadmissible. She would have to be in court. You have to be aware of that. Going back to the documentation, why I said it's important for it to be certified, is because those other witnesses do not have to come into court to testify as to its authenticity. You don't have to ask questions of such as, what do you do? I work at DeKalb Medical. Well, how long have you worked there? I worked there for 5 years. And what do you do there? I'm in charge of the records department. And are you familiar with this case? And that rigmarole, you don't have to do that once you get the record certified. So be mindful of that. Once all the evidence is presented, the person in the black dress makes a decision. Now, the person in the black dress can decide either that day or they can, let you know via mail what the decision is. I've seen it done both ways. I prefer they do it that day, but sometimes they do send it to you in the mail. Now, once that is done, depending on where you sit on that side of the equation, you can appeal. You would appeal to, in Cobb County, I think it's the Superior Court, but every jurisdiction is different. In DeKalb, you would appeal to state court. In Gwinnett, I think it's state court. Or you have the option. Sometimes they'll give you the option of which jurisdiction, which form you want it in. Once you get there, like I said, it's a different story. Because at that point, you can ask for a jury trial. At that point, you may want to do it with an attorney. Appeals must be made 30 days from the judge's decision. Now, let's say you're the defendant and you had to pay $5,000 in damages and you're like, no, I'm not doing that. I'm not sure if Cobb does this, but in DeKalb, what you would have to do is put $5,000 in the court registry, and then it's sent up for appeal. Do not hold me to that. I just know that's what DeKalb has done. So you may want to check to see if that's the process for the other counties. Yes, sir.
Yeah, just general information. You mentioned 30 days before on certain things. Are you talking calendar days or are you talking work days?
That is every attorney's question, because sometimes it's just not clear. The statute doesn't necessarily say 30 business days. So with that in mind, just assume it's regular calendar days. That way, if you're wrong, you're still right. Yes, ma'am.
If you appeal and it goes to state court, is the cap still 15,000?
No.
Now you can go up.
Now you can go up. Now you can go up.
More than the original?
You can amend the complaint and add to it if you wanted to.
Excellent.
Yeah. Everybody understood that? Mm-hmm. You had a question, sir?
Yeah, with that same line with the appeal, can you just, like in magistrate, you was filing on one thing, then go to state and appealing the ruling, if it rules against you, then go to state and then just change the whole?
Think of this appeal process as a do-over.
Okay.
Look at it in terms of the magistrate court hearing was a dress rehearsal.
Okay.
It gives you the opportunity to hear a little better what your case is, what the other side's case is, and try to navigate what your problems were, okay? If you're on the wrong side of the issue, of the judgment. And then just refile it, appeal it and refile it. Essentially, you're doing it all over again. It's not like if you are in state or superior court and you're appealing, because at that point it's going to the Court of Appeals, assuming they take it. This isn't that. This isn't that. It's not that cumbersome. So I would look at it, and like you were saying, I would amend it and see if you can add on some more stuff. Yes, sir.
On that, was it $5,000, you said?
Say that again, I'm sorry.
That's not me.
Oh, I'm sorry.
Did you say it was $5,000?
No. That was just an example.
I understand, but there's a filing fee. That should be folded into that.
Yeah, you would have to, and I would call the other jurisdictions and find out what the filing fees are for the appeal process too. Yes, sir.
And you mentioned there was a backlog, and you've been waiting since 2018 on a particular case. That's in state or superior court.
You would be subject to that backlog.
So what is being done to streamline that process and clear up that backlog?
So what some jurisdictions have been doing is getting more private attorneys to take on more criminal cases and do just those backlog cases. Other jurisdictions, like I think Cobb is caught up, right?
Almost. We have an ARPA court, so we have a separate court
Right.
dedicated to serious violent felonies to hopefully free up some
Right.
time from the other judges.
Yes.
If going back a little bit, if I'm on the stand, I present my stuff, they say their thing, and then they question me, I'm on the stand. Can I object while I'm on the
Yes.
stand, while asking questions?
Yes. Oh, good point. You can make objections. You can make objections. But remember, this is like the People's Court on TV. It's not, the idea behind magistrate court is to be formal, but not too formal. To be respectful, to keep the same level of decorum in state and that exists in state and superior court, but it also provides people the opportunity to be people and not lawyers in solving a dispute. But yeah, you can make objections. I think someone else had a question. Yes, sir.
Before we get off the trial, on the plaintiff, if I don't show up, you said just was dismissed. Is that like a dismiss with prejudice or without prejudice? Or would that be just?
Ooh, you all into it. Typically, it's without.
Okay.
So you could bring it back. If you dismiss with prejudice, you can never bring it back. Like, for example, let's say it's a jury trial, and the jury is sworn in, it's impaneled, it's sworn in, and you don't show up for court. It's dismissed with prejudice. You can never bring that again.
Okay.
I think you had a question. Yes, sir.
What if the defendant don't want to pay the court costs, even though they're clearly in the wrong?
The hardest part about all of this is going to be collecting your money. The easy part, is getting a judgment, one way or the other. The hardest part is getting your paper. That's going to be hard.
Even if it's a business?
Even if it's a business. Because guess what? There's this thing called bankruptcy. Chapter 7. If you don't believe that's real, talk to me offline. Does anybody have any questions about this? Because, yes, sir.
I'm just asking a reality question here. If you ask for a trial by jury, will you get one before you die? I mean, I'm 76, that's why I'm asking.
You're going to outlive everybody in this room. What you talking about? But technically, in theory, yes, you should. You should. But here's the thing, and I'm not trying to be mean or callous, okay? If you have somebody in your life that you really trust, that's when that person will assume the lawsuit if something should happen to you. So it would be, he or she would be acting as your, assuming you have a will, executor or administrator if you don't have a will, acting on your behalf to continue to prosecute that suit once you've passed away.
Okay.
So you still have that option. The lawsuit doesn't die, God forbid, if you did.
Is there something you need to file to make sure that happens, or do you just need to have an executor? If you're
I would have an executor appointed, or meaning I would have done a will, says the man who still hasn't done his yet. But yeah, I would too, yeah, isn't that bad? I would definitely get a will done and make sure that that is included in there, that if I have any active, that's a good point by you. Both of y'all just made a good point.
They have automatically,
Right.
depending on the county, automatically have the ability to do any legal action on
Right.
the estate.
Right.
Built in terms of Cobb County, I know very well, code and statute. They have a broad list of abilities.
But I would make sure that whoever assumes that responsibility is someone that you trust.
How do you know? Oh, sorry.
Yes.
This is my reasoning for wanting a trial by jury. Hey, I think I'll get a fair shake. I don't know if they get an attorney and everything to the judge, you know how that goes. But also, I'm gonna be representing this myself against the attorneys. So the person that I'm suing is gonna have to weigh, do they wanna pay these attorneys or do they wanna mediate? Am I wrong to think that way?
No, no, because here's the thing too, and I need to touch on this a little bit too. State and Superior Court, like I said, it's different rules than Magistrate Court. There is what's called discovery process with State and Superior Court, and that lasts 6 months. During that time, you can be sending interrogatories back and forth, requests for production of documents and requests for admissions, and then you're conducting depositions, and that's 6 months. And all that time you're building your case, okay? And then once that time expires, that's when the judge can put it on a trial calendar and you're putting 12 in the box or 6, whatever, and you're trying the case. But during that time also, you have an opportunity to mediate. The mediation process exists there too. And it's one that I think, you should take advantage of. Because sometimes you can get a better result than you can with a judge and jury. And I'm just going to leave it right there for right now. Yes, ma'am.
If your only evidence is audio evidence, but it's pretty ironclad, with Georgia being a one-party consent state, will they accept that just as the audio, or do you have to have it transcribed as evidence, or will they throw it out because they didn't know they were being recorded?
They won't throw it out because they didn't know they were being recorded. The question is, how are you going to get it in?
How am I going to get what in?
The audio recording. Is it something that you? Let me do it this way. You and I are having this communication, and I have been the big bad wolf and done something terrible. You are recording the conversation, right? So you can authenticate it. Meaning, I had this conversation with Derek Rouse. And I recorded the conversation. I know his voice, I know my voice. This conversation was recorded on such and such a date. It accurately reflects the tenor of the conversation and what was said during the conversation. Your Honor, I wanted to introduce it. That's what I'm talking about. You're gonna have to do it that way. So it couldn't be Kim and I are having a conversation and your phone is in there and it's recording it, or the gentleman in the back is recording it and then gives it to you, and then you want to use it in the evidence. He would have to come in there and testify as to the authenticity of that phone conversation in order for it to become evidence. But if you are one of the persons on the phone call, yeah, that's not going to be a problem. That's the first point. The second point, transcribe it anyway.
Okay. bring that.
And Google is very good at that. I don't know if anybody has tried that. My assistant schooled me on that on one of the cases that I had, and it's very good at it, at transcribing the audio. It's not great, but it's better than paying a court reporter to do it, and you're paying over $200.
So I think what I was really trying to understand is there any situation that could transpire whereby they would say, we have to throw this out? Like, it's me and the other person having a conversation. But with Georgia being a one-party consent state, is there anything they could do to say, we can't accept this? Because that's what all the evidence is that tape. Given what you presented to me, I can't think of anything right now. But I will say this too. The person that you're speaking with is the defendant, right? What the audio is going to essentially do is bolster your position. You can testify as to what this person said to you or said during the nature of the conversation, because that person is a party opponent. And that's an exception to one of the hearsay rules. Like, I couldn't testify as to what this gentleman said in a conversation that we had that I didn't have any way of showing he said it, but for me trying to get him, hey, you want to testify that, you kicked me in the shin, that kind of thing, because that's hearsay. You would have to have someone or some way to authenticate or make him available to make that testimony. It's not what you're talking about is an exception to the hearsay rule. It's called an admission by a party opponent. So anything that person said to you during the nature of that conversation, that's not hearsay. But if someone else were to say, man, Derek said this, that, and the third, and the defendant says that this person said, Derek said, that's a lot, isn't it? That would be hearsay. I'm trying not to confuse you because hearsay can be confusing, but. That's okay. Well, last question is there any place we can look to get all of these terms? Like, I understand objection, hearsay, objection, substantial or asked and answered, but is there like a list of all of those in case you
Black's Law is right around the corner in the law library. Easy to get to, easy to check.
Black's Law?
Black's Law Dictionary.
Oh, Law
It's
Yeah.
like the Bible.
Yeah.
Is that on, well, rather than looking
Call my office, and this goes for everybody in the room. Call my office. There's some things that I would be happy to send you that has hearsay stuff and how to lay foundation stuff. I'll make you lawyers before you know it, man. You're gonna be sitting down taking the bar.
What do we ask for or send an email?
Just ask. I want to say ask for anything you want, but on this topic, for this, what I'll do is there's a list of common objections. I'll send you that. I'll send you some stuff dealing with evidentiary foundation stuff, meaning how to get, I almost said another word, how to get stuff in the evidence, admitted as an exhibit, things of that nature. There's magic words, quote unquote, that we have to say when we're talking to a jury and trying to get evidence admitted. Like I said, magistrate court is formal, but it's not as formal. So you wouldn't have to go through as many hurdles in magistrate court, but I'll get it to you anyway. It's better to have it and not need it than to need it and not have it.
Is that going to come by way of the presentation, via the email that?
In the PowerPoint presentation, my email is my email address on there?
It's on the first page.
Okay. If you email me, I will make sure you get it. Yes, sir.
The law library, is that open to the public?
Yeah.
It's just down the hall.
Okay.
Yep.
Yes, ma'am.
Yes. Okay, say for instance that you want a default judgment, and you're ready to collect on it. You know where the person works, and you want to just garnish the salary to get it. How would you start the process with that?
This is the last document, I think. Like I said, you.
I read that, and I understood that,
Mhm.
I know where the person works,
Yeah.
so when you,
So what you would do is you would have to file the, I always say this wrong, the FIFA, whatever they want to call it. You file that first. And you file that with the magistrate court, clerk's office. From there, you file the paperwork to begin the garnishment. And then the court's office will send that to the place where the person works and begins the garnishment proceedings.
okay, but what if it's like a major place, like somewhere like UPS or something like that? How would you get the address and all of that for, like, you kind of know where they work, but you don't know the actual street of it, of where, how would
Okay, that's a good question too. Now you could do, well, let me go back. These are the 4 ways that you can try to get your money. The FIFA places a hold or lien against the losing party on their house, property, what have you. I'm explaining this to everybody else. We're gonna get caught up to you in a minute. Garnishments, you can garnish a person's wages, you can garnish at their job, you can garnish from the bank accounts, things of that nature. Levy, you're doing the same thing on you can have the sheriff's office go and try to collect the car. That's the value of what your damages are. And lastly, you can get a collection attorney or collection agency. Yeah, you can be a creditor. That's cool. But back to what you're asking me. So there are some other things that you can do. If you know, but you don't know where they work, there are documents in the clerk's office that are called interrogatories. Have you filled those out yet? Or had that? Okay. So what you do is you get those interrogatories. Those are collection interrogatories that you use after you have your judgment. And you send it to the defendant and say, you need to answer these questions. And some of them are like, where do you work? How long have you worked there? Things of that nature. They have to answer them. If they do not answer them, then the judge can come hold them in contempt of court, okay? Or compel them to do it. That should get you the information that you're looking for. And once you have that information, then you can start with the garnishment process. Yes, sir?
What are they ready to pay? What do they actually pay?
Say that again?
If they're ready to pay, you know, do a settlement or what?
Uh-huh.
They actually pay.
How? However you two decide to do it. Like they could either pay all at once, they could pay in installments. Best thing to do if you are, let's say you work out in mediation, right? Man, I owe you, yeah, you're right, I owe you, I'm sorry. I owe you $5,000. Will you take $250 a month or whatever, whatever you agree to? Let's say it was $5,000, what would you take a month?
$250 is fine.
Okay, so we worked out our deal. We worked out our suit.
Yeah, for a argument.
Right, so I'm paying him $250 a month for the duration of the $5,000. I do not do math that well, so I don't know how much that is, how much time that'll be.
20 months.
Thank you. So what we would do is we would draft with the mediator what's called a consent order agreement. And what that does is it lists the details of the agreement. And it states when stuff is supposed to be paid, how much is supposed to be paid, and the terms of the payment, how long it's supposed to last. And once that's done, you go back to court. Hey, judge, we worked out our agreement in mediation. Here's the consent order. Judge looks at it, calls you up there. Plaintiff, you agree. Defendant, you agree. Yeah, okay, sign it. And then you're done, right? What that does is it means that if I breach that agreement in any way, you can come after me for everything. But that's how you would work it up. I would do it that way. Yes, ma'am.
When you first come in and you get the mediator before you guys sit down, do you tell them all your evidence you have?
No.
With discovery?
No.
The mediation is just to say, here's my point, here's your point, let's try to settle. They say no, we go to the judge. Then I say, you did this, he says, no, I didn't. Then I bring my evidence and go, yes, you did, it's right here on the tape.
You can do it that way. You can do it that way. Your mediation is what you all make of it. It can be as successful and fruitful or as bad as you want it to be.
But is the point of it is to try to resolve it?
The point is to try to resolve it, but what I'm saying is some people come in there with a different mindset. Some people come in there with the mindset of, I'm not agreeing to anything no matter what. And it's reflective, and you'll have one side that is really trying to work and the other side that's not.
I guess what I'm saying is, and I'm not disputing because I want to do whatever's right, but if the point of it is to try to resolve it, why wouldn't you say, I've got you on tape saying this, so let's just resolve this and not go through all this?
This is where the legal strategy comes in. When we first sit down, you and I, he's going to be our mediator. We're parlaying, okay? We're going to parlay. You have me dead to rights on tape. And I don't know there's a tape. So what you would do is, well, Mr. Mediator, on XY date, he and I had a conversation. We had an argument about this, and he did X, Y, and Z, and this is what happened, and this is why I feel that I'm wrong, and this is why I'm here. And I'll say, I don't know nothing about nothing, and she didn't do that, and all just completely unreasonable, right? And then that's when you try to get us alone and talk to us individually. That's when you give him the information about the tape, the mediator. The mediator will then come to me and say, well, Mr. Rouse, I hear you. However, and then he tells me about this tape. And then hopefully that'll make me change my tune a little bit. And then we try to work it out in some way, shape, or form, or fashion.
Okay.
I'm a big fan of Ali Foreman. You know that fight?
Yeah.
The rope-a-dope fight? Mm-hmm. That's me. Okay? I got that right, Ali Foreman, right? That's fight. Okay, I wasn't around to see the fight. I had to see it in replay. But what I like to do is to give somebody a false sense of security before I drop the hammer on them. And that's what I'm saying that I would want you to do first. Because it's easier to get a resolution if someone is overconfident than it would be if you presented everything. Because you don't want to present everything at one time to give that person time to come up with an answer. Yeah. So I'll rope-a-dope you. And then we'll see what happens after that. Yes, sir.
Just to piggyback on her, what if I got all the text messages, but she don't have all the text messages?
Then introduce the text messages.
Well, that's not me. That's not me.
That's not you.
No, I'm just saying that's what she would probably say.
Oh, no. Because here's the thing. Make sure, and this is the thing that kills me with the text messages. I need you to be able to show the phone number or something that says that this is from this person. If you can authenticate the phone number or something that says this is Shirley, and or some form of identification of that defendant or that plaintiff, because it works both ways.
What if they deny the number though?
They can deny it all they want to. If you really want to go down that rabbit hole, then find out who her cell phone provider is and subpoena the records that way. You can do that too. All you need is a
person.
You
can do that as a regular person.
Yes. There's two types of subpoenas. There's a witness subpoena and a production of evidence subpoena. All you need to know is where to send the cell phones. All you need to know is where to send the subpoena to the cell phone provider. If you got a phone number, if you got the provider, and you got the person's name who purportedly owns the phone, you're good. You should be able to get the records.
So how good did that work with one of those burner phones?
See, you talking about some other stuff. I don't know what you be doing over there, brother. That's exactly. It's not gonna work. It's not gonna work. It's probably not gonna work. But that's when you call my office and you say, "Hey, Derek, look, I got this issue. Do you have a very good investigator?" And then I'll give you the name of the investigator. That's something that they can do. Anybody has any more questions? Yes, ma'am.
How do you know, I know like in regular court, like if you go through state or whatever, things you have to use the right terms, like you said, because things could be thrown out if you don't say it the right way. How do you know if something is actually justiciable? If you know, like for example, you harmed me, but then as a result this happened. You didn't do this directly, but it was an effect, and they could say this has nothing to do with that. So how do you put it together and know that legally, you know?
Let's go down that rabbit hole. Y'all want to take a trip with me? Let's go down the rabbit hole. So I'm walking down the street, minding my own business, feeling good. And this dog comes out of nowhere. And actually almost happened yesterday while I was getting in the car. And this dog comes out of nowhere, and it's a pit bull, and it just bites my leg and tears it up. And I have to go to the hospital. Right, and I get rabies shots, you know, sutured up, and want to hit somebody because the junk hurts, and all that jazz. So later down the road, the leg starts to not acting right, but it's still attributable to that dog bite. So I ended up losing the leg because there's an infection somewhere and blah, 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 blah. And I lose the leg. So my claim against the owner of the dog went from magistrate court to state and superior court within a matter of however long it took for me to lose the leg. But it can all be attributable to that first incident. But for that, none of that would have happened.
No, but what if you're walking down the street and a person jumps in front of you that causes you to fall in front of the dog, and then the dog bit you? So technically, it would.
I'm suing both.
Another value.
I'm suing both.
Because, okay.
You sue both.
Well, let me just ask my specific, because I think I'm being too vague. If somebody does something to you that causes you anguish and discomfort, but as a result you go to someone else to fix what they couldn't fix, and you can't get it done, so you end up paying for it yourself. So technically you wouldn't have had to pay for it had they done what they were supposed to do, and because of the anguish they caused you, you went somewhere else. So they didn't actually, they did something to start the process, but the fact that you paid someone else is not their fault. It was an option.
So hold on a minute. I think we're done, actually.
I think we're done. I'm sorry.
Yeah, we're done. So essentially what's going to happen, it's still going to come back to that person.
It will, okay.
It's always, 9 times out of 10, it'll come back to that person, unless this person in the middle